Thank you, Ostis. Thank you, everyone, for being here and for sticking around before the breakout sessions. So you heard so far how things become EEA law, how EU law becomes EEA law. And then the question is what happens next? What comes next is that the states have to apply the rules and companies and individuals benefit from the rights in the EEA agreement. And for that, you have ESA and the EFTA court, and we are here representing our respective institutions, expressing our personal views.
Of course. So, thank you. Now Christoph was so kind to introduce us with his last slide, so we don't really need this slide, but we have then, as on every slide, some nice pictures from the EFTA states, and then I'll give the floor to Melpo to say a few words about enforcement. And I think Ásdís highlighted one of the key sort of functions or why we are here. The court and ESA look at things, how they are once the legislation is into the agreement. And then the enforcement, and that's of course ESA.
So we come in first as ESA. The first thing we do is that we check that all of these 8,000 pieces of legislation that are incorporated into the EEA agreement, we first check that they're made part of the internal legal order of our 3 states. That's a very tedious work, and it's an automatized work to a large extent. So if this hasn't been done, then we have legal means that we will explain later to react to that. But not only do the EU law pieces of legislation need to be part of the internal legal orders, they also need to be applied in practice and to be implemented correctly. So this is what we do when we monitor compliance. We check the books, we check the quality of the law in the national books, and we check that they are a reality in practice. When we do that, we look at both the EEA agreement itself, so the fundamental freedoms, competition and state aid provisions that are in there, but also the surveillance and court agreement. And those 2 agreements have a very big difference between them. The EEA agreement is the agreement that binds our 3 states with the EU and its member states. But the surveillance and court agreement is an agreement that gives effect to that, and it's only among our 3 states, which is what we call the self-policing pillar that we have, and that Olafur will say a bit more about.
So then, yet again, we have this. I think I missed the first presentation, so I'm counting 3rd or 4th time today. But here we're focused on the middle. You have what Melpo calls the self-policing, which is ESA and its monitoring and enforcement role, and the court and its jurisdiction to give the authoritative interpretation for the EFTA pillar. So here we're not looking at the committees at the bottom, but we're looking at the middle and the bodies that are there and how they are crucial to the integrity and success for now 30 years of the agreement. And we'll sort of, I think we have an obligatory ad for our breakout session. That's the only session where you'll really learn about these in more detail. And I would add fascinating detail.
So these are the 3 persons at the top of ESA, ESA's college. They are each appointed by one of the states and nominated by each of the states and appointed by common accord by the 3 states who need to agree on the composition of college. So college takes decisions for ESA, sets the priorities and guides the work of the services. They are the ones that take responsibility for all of ESA's decisions. This means that whenever there is an infringement or something that is going wrong in the actual implementation of EEA law in our states, it is not the Commission that has a role to check that. It is an organization, ESA, which is set up by the 3 states pursuant to the surveillance and court agreement.
Then similarly, the court is composed of 3 judges, each nominated by an EFTA state and then appointed by common accord by the state. So that's more or less the same as with ESA. Then the jurisdiction of the court is, of course, confined to the 3 EFTA states, or the EEA EFTA states. So that's the states that come within it. And then it's, I say here, largely corresponds to the jurisdiction of the Court of Justice. I don't like that sort of being that approximative, but I think for the time being, I think that's good enough. And then we will, in this presentation, once Melbo has explained a bit more about ESA, I will go into more on that. And there we have the 3 current judges.
Want to be keeping an eye on time so that as this doesn't need to make big eyes for me. We are now moving us to the part of how do we find out that there is an issue, or how do we monitor and ensure there are no problems with implementation of EEA law. We have a general monitoring role where we check the legislation, as I explained. We also look at newspapers and try to see if there is any issues. We also can receive complaints from individuals or businesses that come to us and say that they think there is something wrong in the way the rules are being implemented or applied. The states have reporting obligations. They have to, pursuant to the legislation that they have decided to put into the agreement, have decided that they will be coming back to us to say how they've done certain things. We do conformity assessments. We have a bit less capacity than the Commission that systematically does them, but conformity assessment is basically a new piece of legislation comes in. We do a very quick check as to whether all the pieces of the puzzle that are in the EEA law are also in the national legislation. So we don't go deeply, but we check big amounts of pieces of legislation. And we also have the capacity to take own initiative cases, which means that when we think there is something to explore, and at the beginning we don't always know if it is problematic from a legal point of view, we can open a case. Whenever we investigate, we don't stay in our very nice EFTA house in Brussels and think of what we think happens on the ground. We have a dialogue with the complainants, if there is complainants, but primarily with the states. We try to understand what their perspective is, how they think they are complying with the rules, how they apply them in practice, what solutions they found to problems they have encountered. And this dialogue, the earlier it happens, the better it is in terms of outcomes. Our objective is not to go after the states and open infringement cases. We are not proud of when we have to do it. We don't find it the best way. The best way to ensure compliance is to avoid situations of non-compliance or to remedy them very quickly. And as part of that dialogue, we also explore with the states what our understanding is of what EEA law means, and we help the states find solutions to problems that we've identified. If things don't go so well and we don't find solutions early, we have some tools at our disposal. The first one that we do is a letter. These steps are exactly like on the Commission side, what the Commission does with the member states. So we have a procedure that's very similar to what happens on the EU side. The first thing we do is we send a letter, a formal notice. So it's a very formal letter where we explain what we understand EEA law means, and how what we found out about how the states implement those rules is in breach of those rules. Then the states get a chance to respond and maybe contradict us on our interpretation of the law, or correct the factual elements that we had on which we based our assessment. If we still think that this is a problem with EEA law, if we still think there is a breach, then we move to the last part before going to court, which is a reasoned opinion. And there we request the states to change their law or law and practice to come within the limits of what EEA law provides. Through these stages, dialogue still continues. Even though we go through the formal steps, the door is always open. We try to help identify how things can be improved on the ground. It is not an objective in itself to reach the last stage. We are actually very proud of all the cases that get resolved before getting to court. So even if after the second stage, the reasoned opinion, if within the deadline, it's usually 2 months, the states have not changed their rules or practices, then we have the possibility to decide to refer the matter to the EFTA court, which means that we take all the case that we have built from the beginning, the dialogue that we had with the states, everything that we have explored, our understanding of what the law means and how the national rules are breached. We take that as an infringement case to the EFTA court, asking the EFTA court to declare that the state has not complied with EEA law. And it is the court that gives the final interpretation, so I give the floor to Olafur.
Then we start with a quote from the, I would say, the most important case in the court's history. We didn't give the name there on this slide, but if someone is interested, it's called Sveinbjörnsdóttir, unless you're Icelandic and you prefer to call it Erla Maria. But it is the case which said that the EEA agreement is such, the homogeneity objective is so strong in the agreement that state liability is present under its term. And I just reviewing the slides this morning, I realized we haven't said the word homogeneity anywhere. And that is the key word of the agreement. If you want to retain one word from today, it's homogeneity. And it's both in the incorporation phase, that it's to ensure that the rules are the same, but when ESA and the court take over, it's to ensure that they mean the same and they actually, and the homogeneity is really ensured. It's not only on the books, but also in practice. So the EEA agreement, this is rather technical, and I will just go very briefly through this, but this is, as Melpo was saying, here we have the surveillance and court agreement playing a key role, because both as regards ESA and the court, the EEA agreement itself only says to the EFTA states, you have an obligation to set out these two bodies and discharge, give them particular functions to discharge. And that is then done with the surveillance and court agreement, which is an instrument between the three EFTA states, but of course, as our breakout session will explore, heavily influenced by EU law terms. So I will now very briefly mention the different types of cases the EFTA court deals with. We have direct actions and advisory opinions. And then when we look at the direct actions, it's twofold. It's infringement cases against the states, and that is really the continuation of the slide where Melpo says ESA is investigating, starts a case, and then that covers those cases which go all the way to the court for a ruling by the court. That, of course, is a great minority of all cases investigated and examined by ESA, as it should be. Then, of course, we have ESA in the sort of second box on this slide. We have ESA as the defendant, and that's challenges against decisions taken by ESA, which more or less is on state aid, although there are two competition decisions which have been very high profile and would be interesting to discuss, but we'll leave it for now. So that's really the key element there, is the legality of state aid decisions. We, of course, for those who are very interested, they can see that there is a possibility that an EFTA state takes another EFTA state to the EFTA court. Hasn't happened, and I'm willing to take a bet that even if the agreement lasts another 30 years, it won't happen. But it's still an important feature to have. Then we come to the advisory opinion, and this is based on the preliminary ruling mechanism under EU law, and was one of the complex issues of the negotiations, that the EFTA states didn't want to relinquish sovereignty, or at least to a very limited extent when it came to judicial control. So these are, formally speaking, advisory opinion, not binding preliminary rulings. That, of course, is the first issue to highlight. I've put here on the right-hand side, at least right from my side, that this is the effect of this is that is not so much. because they're always, which I have put within speech mark, followed. There are a few noteworthy distinctions, but I would say that I can almost, with full honesty, say they're always followed. There are exceptions, but not really that important. So this is, of course, has been, as with EU law, been instrumental in developing the principles and rules of the agreement. And the case we mentioned at the beginning, Sveinbjörnsdóttir setting out state liability, was such a reference from the District Court of Reykjavik. And another case rendered on the same day, now over 10 December 1998, so now more than 25 years ago, which is less well known, but probably at least arguably equally important, about homogeneity and how to interpret the EEA agreement. And this was also a reference. This was from the Princely Court of Liechtenstein on some requirements in its company legislation. And there was a principled submission saying, no, this is the EEA, it means something different. And here you see the unequivocal answer of the court, where it ends saying homogeneity should prevail, because that's what it's all about, ensuring homogeneity in the EEA. I think that brings us to our last slide, and we have some time for questions.
Any questions from the audience? Right now, I will also remind you, I don't think they mentioned it, that they have a breakout session this afternoon.
Only twice.
Any direct questions? Yes. Please introduce yourself with name and where you come from.
Good morning. Good morning. Thank you, Asdis. My name is Michel Di Pietro. I am the director of the EFTA Statistical Office based in Luxembourg, and I have a question for the representative of ESA. On one of the first slides, you mentioned that you take action based, among other things, on complaints. And I am wondering who or which institutions are eligible to lodge such complaints. And more specifically, would the Commission, for example, be entitled to approach you and to lodge a complaint about something going wrong in one or several of the EEA EFTA states?
Thank you for your excellent question that invites me to talk a little bit more about how we work with the Commission, which we haven't covered much as part of this presentation, but we can explore more for those who come in the afternoon. I needed to do my piece of advertisement. Cooperation with the Commission and who can lodge complaints. The enforcement of the EEA agreement is split between the two pillars. So on the EU side, anyone complaining against an EU member state would have to lodge a complaint with the Commission. Any person complaining about a breach of their rights on the EFTA side would need to lodge a complaint with us. There is a mechanism in the EEA agreement where if the Commission receives complaints against one of our states, they have to transfer the complaint to us and inform the complainant that they have transferred the complaint to us. So we're always going to be responsible for dealing with complaints against one of our three states or all of them. Whenever we receive a complaint, be it indirectly through the Commission or directly to us, we always talk with the Commission. Homogeneity is key here. We are looking at an interpretation of the same laws that apply on the EU side, and we don't want to give a different interpretation. If the rules are the same on both sides, we should give them the same effect. So we are independent in the way that we form our positions and interpretation. We take responsibility for the independent outcomes that we reach, but we don't reach those interpretations alone. We talk with the Commission services, we talk with the legal service to make sure that we have all the elements to come to our to a conclusion. The Commission has also other means than talking to us about a complaint they've received. If it's a complaint we've received, then that's how it should be dealt with. But we also invite the Commission, if they have things that have come on their radar, to talk to us about it, because we are the only ones empowered to take action at on the legal side of things and the legal procedures. If we move away from a legal and procedural way of resolving disputes and more into the political domain, there are, of course, a whole other world there as to how this would work, and it is beyond the role of ESA to survey it. And that becomes then much part of it could become part of a bigger or a political way of resolving disputes, which is not the approach that was chosen when the EEA agreement was drafted. The EEA agreement was really based on the idea that each side would take care of establish its own procedures to ensure that the agreement is respected, and both parties respect each other's procedures, and by following up on any infringements and bringing matters to court. So there are political means, but we are focusing on the legal and procedures that we have, because that's the most, that's the recipe that has worked so far, and we hope it lasts as long as the EEA agreement lasts. I hope that answers your question.
Thank you. We have run out of time, so you're going to have to catch these guys at lunch or during the breakout session, which will take place just opposite this room in the afternoon. Thank you so much, Melpo and Oliver.